Good afternoon, everyone. Happy to be back here with you again today. Thanks, Kathy. Today we have an excellent line of speakers. We have a pure labor focus today. For those of you who are regularly in attendance, you know that I tend to lean towards these labor topics. Today it's all employer focused issues. So first we're going to have Allison Matthews, who is out of our Garden City office, talking some general guidelines for employee management progressive discipline. So one of these topics that's always relevant and always helpful to get a primer on. Then we'll turn to Hannah Redmond from up here in Syracuse with me, who's going to talk about some Supreme Court cases on the docket this fall that may impact you in your workplace. And then finishing things up, we're really happy to have John Baggy here from our Albany office, a frequent presenter around the state and the country on these topics, joining us for the discussion of the Supreme Court's affirmative action decision and how that really does have an impact on you in the private sector as an employer. So with that, I'm going to turn it right over to Allison from Garden City, who is going to start us off today.
Thanks so much, Kristen. So we're going to give a primer overview reminders on employee management. So how to make sure you're properly managing your employees, and then some steps to take if we do end up having to discipline employees. So one of the things that we see a lot is we get on our end as the labor attorneys, we get a lot of the information about disciplinary matters when we're already reached that point. And we always look at the file to see what steps have been taken along the way to manage the employee. And oftentimes there's nothing there. So it's a good idea and a good practice to put some of these procedures in place, and hopefully you can avoid that disciplinary action. So our goals of employee management, we want to make sure that employees understand what they are expected to do and how they are expected to perform if we need to, how we improve an employee's workplace performance if they're struggling, and of course, if there's nothing more that can be done or something egregious happens, how we can get that employee out of our workplace. So there is a book called Good to Great by Jim Collins, and it talks about how to get people from just being good to just being great. So we talk about that people in general are not your most important asset. We're looking for the right people, and the right people for your workplace is going to be different than it is for another employer's workplace. But we want to make sure that we have the right people on our bus, and how to motivate them and how to get them going and doing what you need them to do is naturally going to go away. And we want to make sure everyone understands if we always have the wrong people there, the bus is never going to take off. So 3 things to think of. We want to get the right people on our bus. We want to make sure we have the people that we want. We're recruiting the right kind of people, the ones that are going to fit the job, fit our workplace. Anyone who's wrong for the workplace, wrong for the job, we want to get them off our bus. And then we want to make sure the people are in the right seats. There's sometimes you see an employee that comes across as not quite the right fit, but then you shift them around to a different position or give them some assistance, and all of a sudden they're going from good to great. So that's really our goal here when we're managing our employees. So employee responsibilities, we want to make sure they're reporting to work at their assigned work hours, they're performing their job duties to the best of their ability, they're attending training, they're abiding by workplace rules and policies, and they're following any lawful directives that are given by a supervisor. On the employer side, we want to communicate the job duties and expectations, provide training, we're evaluating the performance, we're using progressive steps to produce corrective action, we're resolving any workplace complaints that come our way, and we're also disciplining employees. All right, so performance management. One of the most important aspects of performance management is to document what is going on. So that means your documentation that you're keeping in the employee file talks about who is the employee, any other witnesses that are involved, supervisors that are involved, what exactly was going on in that particular situation or that evaluation, to the extent where is relevant, where things happened, when they happened, why they happened, how they happened, because we want our documents not just to be there, but we want them to be reliable, we want them to be useful. So if we need to turn to them down the road, if we do end up in a disciplinary situation, they're actually good documents that we can work from to prove our case. Or if you're trying to manage an employee's performance, we can go back and look at some of those documentations and you can see where someone has improved, or you can see where someone still needs a little bit of work. And that can help you figure out whether someone needs some training, some more support, and we can move them in the right direction so that they're performing up to our expectations. So setting up employees for success. So one, employees should know what they're supposed to be doing. So that often happens with giving a job description or an overview of what it is that they need to be doing in order to fulfill their expectations and their job functions. Any training that they are needing in order to be able to do that must be provided as well. We also want to make sure they understand the workplace practices, any policies that they need to abide by in order to perform, and any workplace rules. So we don't want to have a situation where we go after an employee for violating a rule and they had no idea it existed, and it's not something that we could say common sense, they should have known better. We want to make sure that we do our part to make sure employees know what those rules and regulations are, and also keep the documentation to show that, yes, in fact, we gave something to you. Oftentimes you get into a situation where someone will have no recollection that they got a copy of the employee handbook, and you can pull out that piece of paper saying they signed off on it, the piece of paper showing that they attended the training, and so on. In appropriate situations, it can also be helpful for employees to have a field training person or a mentor if they need to be able to set themselves up and be successful in their work. Okay, so poor performance. There's a lot of causes here of poor performances, but if you look at this list here and ask yourself, which ones you can fix, basically everything here on this list is within an employer's ability to fix to a certain extent. We can help to a certain extent on the knowledge and the skills that an employee needs to develop. We can make sure they understand and we're realistic with our expectations. We can make sure they're in the right job. If it is a poor fit and the employee is never going to be able to do that job, that's a different story. If we have leaders who are not managing the employees properly and supervising them properly and making sure they know what they're doing, it's not always the employee's fault then for the poor performance. Sometimes the employees aren't motivated. That sometimes can fall directly on the employee and there's nothing you can do about it, but sometimes it falls on the leadership. Personal conflicts, to a certain extent, we can manage those as well. If we haven't given anyone the right amount of resources in order to do their job, and then making sure our work culture is one that's going to encourage employees to perform at their best. All of these are within our ability as employers to fix and to cultivate that workplace that gets employees to perform well. Okay, so let's talk about performance evaluations. So performance evaluations, we want to make sure we put employees on the correct path in order to grow, in order to get promoted if that's within their abilities. Improving performance, increasing employee engagement. We want to make sure we can determine training needs, clarify our expectations. It allows for conversations. So if we are talking to someone about workplace performance issues and they're struggling, we can make sure that that's the opportunity for us to find out about that and to correct it down the road. We can evaluate our goals, and we can also have documentation in the employee's file if we need to down the road engage in some sort of progressive discipline. Next slide. So performance evaluations, very straightforward. We have standards. We communicate the standard. We measure performance. We compare the performance to the standards. We discuss it with the employee, and then we implement next steps going forward. Next slide. Okay, strategies that work for performance evaluation. So providing the ongoing feedback to employees, that makes sure they have time to make corrective action. So if I only tell an employee at the end of the year, hey, you didn't do all these things, but there was an opportunity for them to correct it and perhaps have a solid workplace performance by the time we get to the evaluation period, that's what you really want to do. You want to make sure the employees understand where they are, where they're going, and where they need to be throughout an evaluation period. We want to make sure we document performance issues. We don't want to just ignore them and hope they go away. And we want to have that proof that there's something going on. Being honest on evaluations is very important. We don't want to be too nice because then it doesn't do us any good. It's not reliable and useful documentation. And we want to make sure we're consistent and objective, that everyone is being treated the same way, evaluated similarly with objective criteria. Next slide. Okay, so problematic strategies, we went over this, comparing our strategies that work to our problematic ones. So these are also good things to keep in mind and to avoid doing. Next slide. So progressive discipline. So we are using progressive steps where it's appropriate to produce positive corrective action. So oftentimes we have small things that are going on and they are maybe repeated where an employee doesn't correct the mistake. It keeps happening. So we start with, verbal redirection, and that can go to written documentation. It can go all the way to suspension and then termination. But sometimes we do jump the line on this, where someone's behavior is so egregious that just a verbal warning is not going to cut it. We need to go higher. But the idea is to progress along with what is going on with the employee. Next slide. All right, so the benefits of progressive discipline, again, we're trying to rehabilitate. We're trying to make sure that we correct that unacceptable behavior and it doesn't repeat itself down the road. We want to make sure that we're consistently administering disciplinary action if we're following that process and it's objective for all of our employees. And if you do that, it helps to avoid or defend claims that the procedures you were following were unfair or that they were discriminatory in nature. Right. There are different forms of progressive discipline. So this kind of goes from least severe all the way down to most severe. The stars on there for in the public sector, most employees are going to be covered by a law that requires you to have a hearing or for the employee to provide consent in order for you to impose that. But this is the chain all the way from least severe to the most severe. Okay, so factors to consider. So when we want to look at nature of the violation, this is in terms of picking how severe your penalty is going to be. Whether the employee was aware of the rule that they supposedly violated, whether they intended to violate the rule, whether it was an accident, if they have an explanation for why they did it. Sometimes that can be an excuse or something you could accept that would prevent you from disciplining in the first place, or maybe it takes you down the chain a couple notches in terms of the severity that you want to respond to that conduct. Whether the employee has a prior disciplinary record and whether we need to go up in terms of the level of discipline, how long the employee has been around, and the prior performance that hopefully you've documented as part of your performance standards. Okay, so the verbal warning. So this is just an overview of what happens when you sit down with an employee to give that warning. You want to let the employee know of the nature of the meeting, and if it's applicable to them, the right to bring their union rep. That comes in advance. When they come to the meeting, you want to explain the situation so they understand what it is you're meeting about and why it's a problem. You give the employee an opportunity to respond and provide their side of the story. If there are corrective directives that need to be put in place, you give that to the employee right then and there. And even though it is a verbal warning, it's always a good idea to document that the verbal warning took place. All right, so written counseling memo, very similar process to what you're doing at the verbal warning. You're going to identify what the employee did wrong. We're going to go over any progressive discipline that's happened in the past. If this employee has been reminded of things along the road, we want to make sure that's all documented in one place. We want to explain why the employee's behavior was not acceptable. We want to demonstrate that we did take the employee's side into account. In some cases, you may just want to document their explanation because that could be problematic in and of itself. We want to give clear directives for how the employee needs to improve and correct the behavior and what the expectation is going forward. What happens if the employee does not meet that expectation or disobeys that directive? We want to make sure we're fair and objective in this memo. And at the end, you want to make sure that the employee signs off that they received a copy of it. The employee gets a copy of it and a copy goes in the personnel file. Okay, so this is for only public sector employees. This is for competitive class employees, non-competitive and labor class employees with 5 years of service. And then there's veterans and exempt volunteer firefighters. There's an 18-month statute of limitations, and the employees can be suspended for up to 30 days pending the outcome of the charges, and that is off the payroll. There is legislation that's pending right now to change all of that, but for now, this is still the rule. There's a hearing in front of a hearing officer, and there's a menu of penalties that can be recommended by that hearing officer that are listed there, and it's one of those 5. You can't do more than one. If you want to do more than one, that's something that would have to be done by a settlement agreement. Okay, so 2 parts to disciplinary hearings. We have a guilt phase and then we have a penalty phase. If the employee is found guilty, we get to that penalty phase. Next slide. I'm going to go kind of quickly here because I can see I'm cutting into the next two sections here. So these are ways that an employee can challenge disciplinary charges, and it also applies to disciplinary action in general. So they can say there's a false accusation, there's an explanation for the conduct, there's no knowledge of the workplace rule, they didn't know about it, it hasn't been enforced, so you're going after them for violating it when you haven't gone after other people. they were never trained, there's some sort of bias, or there's no documentation to show that the penalty matches what the underlying conduct was. Okay, so these are just categories, prohibited reasons for taking adverse employment action. So these are the protected classifications in New York. And you should just keep in mind that everybody belongs to some sort of a protected category. But when you're doing performance maintenance with employees and progressive discipline, we just want to make sure we maintain that objectivity so that we don't end up with a claim that we were being discriminatory in nature. Okay, so these are ways that employees can claim that they were discriminated against, and they're basically going to come up with any reason they can think of why it should not hold up, whether they were treating people differently, the procedures haven't been followed, the employee had stellar evaluations. Again, that goes back to being honest on those performance evaluations. There's no warning. They were given different reasons for the discharge than what actually happened. We have no documentation. The timing is suspect, or our reasons for making the taking the disciplinary action turn out to be false. I'm going to go really quickly here. So even if you win, the cost of litigation is quite high. And if you lose, it's even higher. So these are all the things that come into play if you lose that litigation.
So turning things to a more current events topic, it's October, so it's Supreme Court season. That is when the U.S. Supreme Court starts a new term. And it's always interesting for us to take a look at all of the cases on their docket and how they might affect our workplaces. So Hannah is going to take us through a couple of the more interesting ones. Thank you, Hannah.
Thanks, Kristen, and hello, everybody. As Kristen just indicated, the Supreme Court just started a new term, and so we thought that it would be interesting and worthwhile to highlight a few of the employment law cases that are going to be heard by the court this season. So I'm first going to start with Muldrow versus the City of St. Louis. This case started in the Eastern District of Missouri. It was then appealed to the Eighth Circuit, and it was appealed again to the Supreme Court when a petition for certiorari was filed and granted. The case has not yet been argued, but it is set to be heard at the end of this year. And the Supreme Court issued certiorari as to a single issue, and that issue is whether Title VII prohibits discrimination in transfer decisions absent a separate court determination that the transfer decision caused a significant disadvantage. So as you may know, to prove a discrimination or retaliation claim, a plaintiff has to demonstrate that they suffered an adverse employment action. So the Supreme Court is focused on that part of the discrimination and retaliation analysis and is really trying to narrow it into when and whether under what circumstances, rather, a transfer decision amounts to adverse employment action for discrimination purposes under Title VII. So having walked through the procedural history very briefly and having framed out the issue, let's talk through the facts quickly. So the plaintiff was a police sergeant in the St. Louis Police Department. She was assigned to the intelligence unit for a number of years. And in 2016, after several years in the intelligence unit, she was deputized by the FBI and given privileges similar to an FBI agent. So she still worked for the city police department, but she had these special privileges. Among other things, she worked a pretty routine schedule, something like 8 or 9 a.m. to 4 or 5 p.m. She had significant overtime opportunities of around $17,000 per year. She could work in plain clothes, and she had an unmarked police vehicle. In 2017, there were changes across the department that resulted in a new commander taking over the intelligence unit that the plaintiff worked for. When the new commander came in, he made a number of personnel decisions that resulted in plaintiff being transferred out of the intelligence unit into a new position. Now, when she was transferred, plaintiff did not have any reduction in her salary or her benefits, and her title remained the same. But she did have some new weekend work obligations. Her hours of work were slightly different, and she had some opportunity for overtime, but it was different than the opportunity that she had in her prior position. Notably, when there was this leadership change in the St. Louis Police Department, more than 20 other employees were similarly transferred and moved around to different positions. 17 of those employees were male and 5 were female. So plaintiff wasn't singled out, but she proceeded to file a complaint with the Missouri Commission on Human Rights relating to this transfer decision, and she alleged that the transfer decision was discriminatorily motivated because of her sex. She perceived the transfer as essentially a less prestigious position. So even though she didn't have this loss in salary, benefits, or title, it was less prestigious, more like a basic entry police position. After filing with the Missouri Commission on Human Rights, plaintiff pursued her claims further by filing in the Missouri District Court, alleging violations of Title VII and the Missouri Human Rights Act. She specifically alleged that she was discriminated and retaliated against because of her sex. The city, and there was an individual defendant as well, but the city and the individual defendant moved for summary judgment, and the court granted that motion as to all Title VII claims. So the court dismissed all of the Title VII discrimination and retaliation claims, and with respect to the state claims, said that it was not going to exercise supplemental jurisdiction, so it declined to even consider the state law claims, instead saying those were issues that the state court was best suited to address. After the district court dismissed the Title VII claims, plaintiff appealed that decision as to her Title VII discrimination and retaliation claims alone. So the question before the Eighth Circuit with respect to plaintiff's discrimination claim was whether this transfer decision, the decision to transfer her out of the intelligence unit to this other more administrative position that plaintiff characterized as less prestigious, whether that rose to the level of an adverse employment action. So the Eighth Circuit started with its basic definition of what is an adverse employment action, and that is a tangible change in working conditions that produces a material employment disadvantage. And the Eighth Circuit was careful to say that a minor change or an unwelcome or unwanted change without more is insufficient to rise to that level of an adverse employment action. Applying that definition of an adverse employment action, the Eighth Circuit held that under these facts, in this case, the transfer decision was not an adverse employment action. The court specifically held that an employee's reassignment, absent proof of harm resulting from that reassignment, is insufficient to constitute an adverse employment action. The crucial facts that the court relied on here were that the plaintiff didn't suffer any sort of reduction in title, salary, or benefits. And with respect to the differences in overtime opportunities resulting from the transfer, the court handled that issue by saying plaintiff had other opportunities for overtime in her new position, and she declined even to take advantage of those. So the overtime issue wasn't enough to make the transfer an adverse employment action, even though that the opportunities did differ from one position to the next. The Eighth Circuit essentially found that the plaintiff expressed a preference for her prior position. And in other words, just because she didn't like her new assignment as much as she liked the intelligence unit position wasn't enough to give her a viable Title VII discrimination claim on the basis of sex. So the Eighth Circuit affirmed the lower court's decision and said that the Title VII claims were properly dismissed because there was this lack of adverse employment action. Plaintiff then appealed her claims again to the Supreme Court. And as I said at the outset, the Supreme Court did grant the petition for certiorari. So it will hear this case later this year. The case is set to be argued on December 6th. And this will resolve a circuit split. So there's a difference in opinion between what the Eighth Circuit said, which is you need something more than just a transfer decision. That transfer decision has to have resulted in some material disadvantage to the employee, whereas other circuits have opined that the transfer alone can, under certain circumstances, be enough to rise to the level of adverse employment action. So the Supreme Court will hear this case and provide clarity about when a transfer amounts to adverse employment actions and what circumstances and facts it looks to make its decision. So this is certainly a case that we will be watching, and we will provide an update. And another case to keep on your radar is the Loeffler versus Atchison Hotels case. This is a less fact-intensive case. It's a little bit more procedural, but it's very interesting. This case deals with the issue of standing, and what standing is it's essentially determining whether or not the plaintiff is the correct party to bring a case forward. So it's a question of whether the plaintiff is legally able to pursue the lawsuit. A key component of standing is whether or not the plaintiff has suffered an injury that the court can remedy. So the court has to be able to remedy some remedy for an injury that the plaintiff has suffered. Against that background, the Loeffler case involved a plaintiff with physical disabilities who sued a hotel because its website, as well as the third-party booking websites that it used did not provide information about its accessibility features as required under the ADA. So the ADA has what the courts have called the reservation rule, and the reservation rule requires that hotels and places of public lodging provide information on their websites about what accessibility options are available in its accommodations. And those accommodation and accessibility information has to be available on third-party booking sites as well. What makes this case particularly interesting is that the plaintiff is what we call an ADA tester. So this is someone who has no intention of ever visiting the place that is the subject matter of the suit, or they have no intention of ever purchasing the product that is the subject matter of the suit. Instead, they go out and they search the web and they look for these cases where they can say, here's a place of public lodging, and the website fails to meet the ADA's requirements. So plaintiff was a Florida resident. She was searching the web from her home in Florida. She found this hotel, Atchison Hotels in Maine. She realized that the website was not compliant with the ADA disclosure requirements about accessibility. And so she brought suit. The plaintiff had actually filed hundreds of these ADA compliance cases across the country. And so when the hotel was sued, it moved to dismiss, claiming that the plaintiff lacked standing. The defendant made the argument that because the plaintiff never intended to visit its hotel, she wasn't planning a trip to Maine, she was not intending to go on vacation and potentially book through its website or the third-party booking websites where it was advertising, that she didn't have an injury, she had no purpose for this information, and therefore didn't have standing. And the district court actually agreed with the defendant and said, because plaintiff doesn't have this injury, because she didn't intend to use the services that the hotel provides, she has no standing and could not pursue an ADA claim. The plaintiff appealed that decision to the First Circuit, and on appeal, the First Circuit again focused on when and under what circumstances ADA testers, so people who don't intend to visit the place that they are suing, have standing to bring ADA compliance claims. The First Circuit reversed the lower court decision and ultimately held that the plaintiff did have standing. The First Circuit was careful to say that tester status in and of itself is not indicative of a lack of standing. And holding that the plaintiff did have standing, the court focused on the fact that the plaintiff had a right to the information that Atchison Hotels did not provide. So it pointed to the ADA regulations and it said the hotel has an obligation to provide this information. The plaintiff has a right to access this information. And because of the hotel's non-compliance, plaintiff couldn't access the information, which is enough to rise to the level of an injury and gives plaintiff the right to sue. So the fact that the plaintiff didn't intend to use the information, had no intention of ever visiting this hotel or planning a trip to Maine, didn't sway the court's decision. So the First Circuit reversed the lower court decision and found plaintiff could pursue these ADA compliance claims. Now, this case was actually already argued on October 10th, so just recently, and I actually listened. The oral argument is available on the Supreme Court's website. I listened to that argument, and the first portion of the argument was very interesting because the court focused on this mootness issue. So it turns out that after the petition for cert was filed and granted, and the Supreme Court decided that it would address this ADA tester standing issue, the plaintiff, so Laufer, withdrew her claims against the hotel, and having done so, argued that the appeal was now moot. So the plaintiff essentially is saying there's no case for the court to decide anymore because I've withdrawn my case. So the oral argument focused pretty heavily on that issue. The hotel argued that the court should still resolve the standing issue, arguing that the case can't be moot because there was never an issue in the first place because plaintiff didn't have this injury and didn't have standing to pursue the claims. So the hotel's argument is that standing should be addressed before mootness. And if the court addresses the issues in that order, the mootness issue shouldn't come into play. So I bring up this mootness issue because while this case is one to watch, we have the possibility that the court will dismiss on mootness grounds and say because the plaintiff withdrew her claims, there is not a case or controversy for us to decide. So at the end of the day, the possibility remains that we will not get clarity on this standing issue, but I thought that it was a very interesting case. And again, certainly one that we will watch.
Thanks, Hannah. And, we come across this idea of testers a lot, right? So not just in this context of someone checking, whether the website at the hotel has the right language, but we see it in employment cases too. People applying for a job, not really intending that they don't want that job. They just want to see, what happens. And so this case really could impact a wide array of settings and issues. So thank you.
Absolutely.
Okay, so turning things over now to John. Thanks for being here, John. You're going to talk us through some thoughts about the landscape and how it might have changed after this decision from the Supreme Court. Staying with the Supreme Court theme, I guess, right? So
Right.
Go right ahead. Thanks.
Thank you, Kristen, and thanks for having me. For those of you who are not familiar, the Student for Fair Admissions case versus Harvard was a case that challenged the affirmative action practices of Harvard College. And it's important to understand that that case was decided under the U.S. Constitution in Title VI, which do not apply in a private sector workplace. But while it's not directly applicable to the private sector employment decisions, it is likely, and I know it already has led to increased attention on DEI initiatives and also challenges to DEI initiatives. So we do need to have an awareness of how we should react, so to speak, to this decision. And I will say that I've seen some employers overreact by suggesting that, and pundits as well, that chief diversity officers all need to be fired, which is not correct. And others thinking that there's nothing that needs to be done. I do think as a proactive, mindful employer, it makes good sense to look at what your DEI initiatives are and to evaluate whether or not they go too far. And we're going to talk about exactly when they go too far in a moment. We've done this for a number of clients, reviewing their entire DEI plan or plan document, and giving them some suggestions about what may go too far and how we can address it. So while DEI initiatives are not necessarily illegal, we have to look at each initiative individually and based on their facts to see if it is in fact compliant. I will say the focus really is that not that the Supreme Court decision in the Harvard College case changed anything for employers, but there were certain things that employers were doing that has always been improper. And now there's a better chance that that's going to create a problem. So the focus, when you look at these initiatives, is did the initiative result in a racial preference with respect to terms and conditions of employment, including hiring, promotion, or layoff? One of the EEOC commissioners made the point that it's the Equal Employment Opportunity Commission, not equal employment outcomes. So if you're focusing on the end result, that is, have we hired enough members of X group, as opposed to have we identified the barriers that might be reducing the number of individuals in X group that we hire? If we're focusing on the latter, it's okay. If we're focusing on the former, it's likely not. Also important to note that even legally defensible initiatives may be used as evidence of discriminatory motive. And what do I mean by that? So let's say, for example, you're keeping stats with regard to what percentage of senior management is female or Hispanic or Black. Merely keeping track of it and sharing that information could be used against the employer as evidence that when, for example, someone that's not in one of those groups is passed over for a promotion or to be hired into one of those positions, that is because the employer is so focused on this outcome. Even if the employer is not driving the outcome, but the fact that we're measuring it and putting that information out there could be used against us. So some considerations you need to keep in mind. One, what are your values? How important is it to you pursue these initiatives? Some employers are more willing to take risks because the goal is a noble one. Other employers do not want to take any risks, and as a result, will not come close to that line. So we're going to walk through some DEI actions that I've seen employers take, and then discuss whether they're problematic or not. So let's start with limiting the formation of or treating affinity or resource groups differently based on protected status. If you're not familiar, affinity or resource groups are groups that are often set up that are used to foster employee engagement, and they often focus on protected status, such as LGBTQ+. So if you limit the formation of that, then you are, that's a problematic issue. It's okay if you're going to let folks form these groups without regard to protected status, but if in fact you're going to limit the formation of those groups, based on protected status, that's a problem. Next one, maintaining quotas or preferences for hiring and or promotion of individuals based on protected status. This is also problematic. Again, notice it's focusing on quotas or preferences in hiring. So you're focusing on sort of the outcome as opposed to removing barriers, and that's where we run into a problem. Developing and utilizing creative approaches to bring individuals into the organization, such as apprenticeships, job shadowing, and career transition programs. Not problematic, because again, you're not focusing on protected status. You're looking, what could we be doing differently to potentially bring to diversify our workforce, and such things such as apprenticeship or job shadowing are not only great given this job market, but also helpful in advancing DEI efforts. Evaluating supervisors and managers or executives based on their achievement of or progress toward hiring and or promotion of protected status based quotas. And this, again, is problematic. And there are cases out there that, and some charges that have been brought in the EEOC that have sort of highlighted that there are organizations out there that are literally providing executives with incentive compensation for the diversification of their senior management or their workforce. Now, again, if we're not using a preference to obtain this level of diversity, that's not a problem. If we're obtaining the level of diversity by removing barriers and expanding opportunities, that's okay. Again, opportunity is the focus, not outcome. Identifying and addressing barriers to participation in internships, scholarships, training, and or mentorship opportunities, that would be problematic. Again, what we're trying to do is increase opportunities, so we're removing barriers, perfectly okay. Providing training on empathy, sensitivity, microaggressions, discrimination, and harassment, obviously not problematic. We're required to conduct training on sexual harassment in the state of New York every year. I firmly believe that, given you have to do this annually anyhow, it makes sense to sort of take this training to the next level and start discussing things such as empathy, sensitivity, and microaggressions. Establishing or maintaining internships, scholarships, training, and or mentoring opportunities and or other programs that limit participation based on protected status, such as race, sex, or national origin. And this is problematic. And this is actually one of the areas that got me most interested in this particular area, because we're having a lot of employers calling and saying, we'd like to create a minority internship program. And it's like, what exactly do you mean by that? And we want to create a program that limits participation to certain protected groups. And you can't do that. That's, race discrimination is race discrimination, whether it's against a minority or someone that's not a minority. So one of the things that we often hear in responses, but there are big companies like Pfizer and Morgan Stanley, and they have these internships and they limit participation. One of the interesting things that I found, because we've been looking for cases that sort of challenged the creation or maintenance of those minority internship programs, we couldn't find them. But then when some digging, what I found is that often what happened is such an internship was announced, it was challenged either through an EEOC charge or through litigation. And then there was a change in terms of what the focus of the internship was. So in 2022, it was described as limited to certain protected statuses. Then in 2023, it was described differently. So I think candidly, somebody went to legal, said, we just got this charge. Legal said, wait, you can't do that. And then adjustments were made and the case was resolved. Permitting affinity or resource groups to limit participation based on employees' protected status, that is problematic. And the reason it's problematic is something that candidly, we were having a lot more of these issues years back before we understood the benefits of allyship. If you have a group that's focused on a particular protected status, that's okay, but you can't limit participation to individuals who are members of that protected class. So, for example, you could have someone who's a parent of a gay individual, and they want to participate, and that's okay, even though they are not homosexual, and they should be allowed to. And if not, if you're limiting participation based on protected status, then we have a problem. Outreach to underrepresented groups concerning employment opportunities to expand the pipeline of diverse candidates, not problematic. Obviously, we want to reach out to folks that might not otherwise apply. And as long as it's focusing on opportunity rather than outcome, you're okay. Selecting candidates for hiring and or promotion based on their protected status, obviously problematic. It literally is the definition of discrimination. Identifying and addressing barriers to building and maintaining a diverse and inclusive workplace, such as reviewing and refining performance evaluation processes. Again, totally okay. You're talking about addressing barriers and removing barriers rather than focusing on the outcome. And lastly, actions including training and assessments intended to increase self-awareness and understanding of our differences, not problematic. And with that, I'm out of time.
Well, you timed it perfectly, John, so thank you. That is really helpful, and appreciate all of our presenters joining us today. I also appreciate all of you who have participated and listened, and who could keep coming back each week. So thank you, and we'll see you again next Tuesday. Here's the contact information if you have questions.